Think of constitutional law as the static blueprint of a state. It draws the rigid boundaries of what the government can and cannot do. But within that bounding box, there is a massive, highly active engine running the daily lives of citizens. That moving machinery is administrative law. Two British legal scholars offer the clearest angles to view this machine. Ivor Jennings looks at the schematics. He defines administrative law by the organization, powers, and duties of the authorities themselves. William Wade looks at the brakes. For Wade, the entire purpose of this law is to control governmental power and protect the citizen from abuse. A century ago, the state mostly just kept the peace and collected taxes. But modern welfare states regulate telecommunications, manage public health, and build massive infrastructure. To scale up, the legislature delegates vast power to executive agencies. To keep that delegated power in check, we rely on A.V. Dicey's concept of the rule of law. Dicey argued that no person is punishable except for a distinct breach of established law, and every official is subject to ordinary courts. There is no room for wide, arbitrary discretion. The goal here is not to shut down the state's operations. Administrative law provides the necessary friction, the procedural brakes and steering controls, to ensure the executive engine serves the public rather than running them over. In 1975, the Indian government declared a state of emergency. The executive suspended the right of citizens to move courts for the enforcement of fundamental rights, effectively removing judicial oversight. People were detained without trial. The legal stress test for this period arrived in ADM Jabalpur v. Shiva Kant Shukla. The core issue was whether, under Article 359, the state could legally detain citizens without any judicial scrutiny of the orders. A 4-judge majority ruled that habeas corpus petitions were not maintainable during the emergency. But Justice H.R. Khanna wrote a soul-defining dissent. He argued that even in a crisis, the executive cannot detain a person without the authority of law, and courts retain power to examine it. His view ultimately prevailed in post-emergency constitutional amendments. This tension highlights India's specific approach to the separation of powers. Unlike the rigid divisions found in the U.S. Constitution, India requires a functional separation. Under Article 50, the judiciary is separated from the executive, but the executive and legislature frequently overlap. The limits of this overlap were tested in Ram Jawayaya Kapoor v. State of Punjab. The Punjab government decided to take over the printing and selling of school textbooks, pushing out private publishers. But they executed this without passing any specific legislation authorizing the monopoly. The Supreme Court ruled that while the executive has broad residual powers to govern, it cannot bypass the legislature to create new obligations or strip citizens of their rights. The state needs statutory backing to impose new liabilities. To evaluate whether an agency is acting within its boundaries, courts classify its actions into 4 types: legislative rulemaking, adjudicatory quasi-judicial decisions, routine administrative implementation, and purely ministerial tasks that involve no discretion at all. The distinction dictates the required legal procedures. In Province of Bombay v. Advani, the government used wartime legislation to requisition private property. The owner argued this was a quasi-judicial act and therefore required a formal hearing. The Supreme Court established a clear test. An action is only quasi-judicial if the authority has a statutory duty to act judicially, meaning they must hear evidence and determine rights. If the statute grants wide discretion without a judicial process, the act is administrative. When we look at the legislative function, Parliament simply lacks the time and technical expertise to write every operational detail for complex environmental or financial regulations. They pass a parent act and let the executive draft the specific rules. But there are strict limits to this delegation. In the Delhi Laws Act case, the legislature attempted to give the government the power to extend and even modify existing laws for a new territory. This sparked a debate on how much authority can legally be handed over. The ruling established that Parliament can delegate the subsidiary details, but it cannot abdicate its essential legislative function. The legislature must lay down the core policy. The executive can only fill in the gaps. When citizens challenge executive actions, courts step in through judicial review. In this process, judges do not evaluate the wisdom of a decision. They focus entirely on whether the process met the standards of legality, rationality, procedural propriety, and proportionality. Procedural propriety is anchored by the principles of natural justice. First, Audi alteram partem, no person shall be condemned unheard. Second, nemo judex in causa sua, no one shall be a judge in their own cause. We see this applied strictly in A.K. Kripak v. Union of India. A selection board was formed to choose candidates for the Indian Forest Service. The problem was that one of the board members evaluating the applicants was himself a candidate for the job. The Supreme Court quashed the selection process, holding that principles of natural justice apply to administrative bodies, just as they apply to traditional courts. Any decision affecting an individual's rights must follow these fair procedures. The court didn't require proof that the candidate actually manipulated the scores. They held that the mere reasonable apprehension of bias from a fair-minded observer is enough to invalidate the process. State agencies often argue that strict procedures slow down governance, but administrative efficiency does not justify procedural unfairness. A legally valid decision must be clearly reasoned, unbiased, and completely transparent. The state needs discretion to handle daily operations. But discretion means choosing between lawful options, not acting arbitrarily or with improper motives. A defining test for controlling this discretion comes from England. The Wednesbury Corporation granted a license for Sunday cinema shows, but attached a strange condition. No children under 15 were allowed in. The cinema challenged this as an abuse of power. The court upheld the condition, establishing what we now call Wednesbury unreasonableness. This created a restrictive threshold for judicial intervention. A decision is only reviewable if it is so outrageous in its defiance of logic that no sensible person could have arrived at it. Modern courts have developed additional tools to constrain discretion, such as the doctrine of legitimate expectation. This prevents authorities from abruptly changing policies when they have established a clear pattern of behavior. This was tested in the GCHQ case. The British government suddenly issued instructions banning civil servants at their intelligence headquarters from joining trade unions without giving them any prior warning. The unions argued that because the government had a long-established practice of consulting them before changing employment conditions, the workers had a legitimate expectation that they would be heard. The House of Lords agreed that the past practice did create a binding expectation of consultation. However, they ultimately upheld the ban, ruling that national security concerns overrode the procedural requirement in this specific instance. Legitimate expectation shows that discretionary power is bound by its own history. The state can change direction, but it must provide logical reasoning when breaking established patterns with its citizens. Theoretical boundaries mean nothing if citizens can't enforce them. In India, the primary mechanisms for this are the constitutional writ jurisdictions under Articles 32 and 226, allowing courts to directly command or restrain government agencies. In Union of India v. Anglo-Afghan agencies, the government announced a scheme promising import licenses to exporters based on the value of their exports. After businesses relied on this and shipped their goods, the government reduced the percentage. The Supreme Court struck this down using the doctrine of promissory estoppel. If the state makes a clear representation that induces a citizen to act to their detriment, the government cannot simply back out of its promise without an overriding public interest. Redressal isn't limited to courtrooms. Statutory tools like the Right to Information Act of 2005 force agencies to disclose their records, while the Lokpal Act creates independent ombudsmen to investigate corruption directly at the executive level. These tools shift the burden. Rather than relying entirely on citizens filing reactive lawsuits, the system demands proactive transparency and built-in accountability from the agencies themselves. To handle the massive volume of service and tax disputes, the Constitution allows for specialized administrative tribunals under Articles 323A and 323B. These act as expert bodies, taking the initial load off the regular courts. But the legislature tried to push this further. They drafted rules making the jurisdiction of the Central Administrative Tribunal exclusive, deliberately stripping the high courts of their power to review the tribunal's decisions. In L. Chandrakumar, the Supreme Court shut this down. They ruled that the power of judicial review under Articles 226 and 32 is a part of the basic structure of the Constitution. It cannot be legislated away. Tribunals serve a vital function as courts of first instance. They have the technical expertise to resolve complex disputes quickly. But they can never usurp or block the supervisory writ jurisdiction of the high courts. The executive engine is granted immense power to run the state, but through natural justice, clearly defined review boundaries, and the permanent supervisory jurisdiction of the constitutional courts, the system is engineered to ensure the state never outpaces the law that created it.